The Isaiah Factor Uncensored starts right now.
And welcome to the Factor Uncensored. Now, last week has been a huge blur of devastating news out of Uvalde for all of us. But you may have missed a very important headline out of the Supreme Court. We all missed it. One of the court's latest rulings cuts off the lifeline for state inmates trying to get a second chance at freedom with their case. Justice Clarence Thomas wrote it up. It deems federal courts are barred from considering new evidence in cases based on bad legal help. It's a pretty big deal. I asked my guests about what this means for all inmates all over the country, and it's not good news at all.
And, there was a time when a state prisoner could go to federal court and expect to get a fair shake. There was a time that when a state prisoner couldn't get relief in state court because a locally elected official, a judge, was just ignorant of the law or maybe even racist, that state prisoner could then go to federal court and get a real jurist who would give them a fair shake. And evidently, with this opinion, the Supreme Court has yet again undermined that right, such that a state prisoner cannot even get heard in federal court, cannot even get the federal court to hear the merits of their claim because of procedural technicalities.
Now, we're hearing from Justice Thomas. He's saying the states should hear this, or the states should take care of this. This shouldn't be in the hands of federal courts, even if someone has evidence indicating that they did not commit a crime, or they have a faulty lawyer who didn't do their job. They still cannot go to federal court, right, Mike?
That's correct. I mean, what's technically what they decided in this case is if a defendant, even in a capital case, which these were capital cases, if they have an ineffective trial lawyer and their lawyer on their first writ in state court does not raise that issue because that lawyer is also ineffective, then although they can raise that claim in federal court, perhaps they cannot develop a record on that claim. So it's a right without a remedy.
Judge Mike Fields, when you hear the ruling by the U.S. Supreme Court, your thoughts on that?
What we're looking at now is a rolling back of an opportunity for state inmates to represent their case to the federal court. What Justice Thomas has said is that if you have not raised an issue at the trial level, if a lawyer has not raised an issue at the trial level, then that's going to be counted as trial strategy. And the Supreme Court is not going to second guess trial strategy any longer. If you, as Mr. Ware said, have an incompetent lawyer who didn't raise evidence that was in existence at the time of your trial, then your Sixth Amendment right to effective assistance of counsel may be limited by this assertion that, hey, you know what? That may have been an ineffective lawyer, or it may have just been his trial strategy. One thing that I will disagree with Mr. Ware, and I do appreciate his fervor for this issue, is the framing of judges at the state level as incompetent. I've served as an active judge for 20 years. I now sit as a visiting judge on occasion, and some of the brightest minds I've ever come across have been elected judges. So I want to make sure that we understand that at the state level, there are some really great jurists out there. And at the federal level, there are some that are not so great. You get all kinds.
And Mike, I'm sure, and I heard you when you said you could run, for example, into a racist judge, which is very possible on the state and federal level. You just want to have that fair shot, or at least that second chance, right?
Absolutely. Absolutely. And, like I said, there was a time when you could expect to get that at the federal level. And of course, and let me be clear, I'm not trying to indict the whole state judiciary. As Judge Fields said, I've had some excellent judges at the state level, but you never know what you're going to get at the state level. And like I said, there was a time when, you know, if the judges at the state level flagrantly failed to recognize a violation of your constitutional rights, say to effective assistance of trial counsel, then you at least had a decent shot at going to the federal judiciary and having that federal constitutional right vindicated, or at least heard on the merits. And what this case does, it prevents the federal judiciary from hearing that constitutional right on the merits.
And
now,
Isaiah,
Mike, go ahead.
I'm sorry. You know, Isaiah, wanting to chime in because these are issues that it's not just regular kitchen table talk. And so sometimes you got to cut this stuff up into small bite-sized pieces. This really is about the Supreme Court saying, we have been hearing cases all over again that were in state court, and now we're hearing brand new evidence all over again in federal court, and we don't want to do that anymore. We want all of these issues to be raised in state court. Here's the problem.
But Judge, for those who may be innocent or have an ineffective attorney or new evidence, so damn what if they're inconvenienced? They are the U.S. Supreme Court. Right.
Understand. That's what they're saying. That doesn't necessarily make it a good thing. Mm-hmm. I want the public to understand what's being said by the Supreme Court at this point. They're saying we don't want to hear all of this stuff over again. And what the people who are being wrongfully convicted are saying is, you didn't hear it in the first place. No one heard it. The lawyer either was too ineffective to present it, the judge didn't appoint the right investigators, legal experts, and folks that we needed at the trial to present our case in a way that was effective. Help. I didn't get effective assistance of counsel. The Constitution says that I should. Federal court system, help me. That's what we're turning down now.
This is a very important story, and if you didn't get that, Google it, look it up. If you have a family member who may be in prison and they can't get out, but they have evidence proving they're innocent, they can no longer reach up to the federal courts. That's a no-no. Incredible. Still to come, as we mentioned, this ruling cuts off a vital lifeline for inmates. We continue to look at how it impacts them, and was politics involved? When we return, you're watching The Factor Uncensored. Welcome back, and we're back with that very important Supreme Court ruling you may have missed last week because of the Uvalde shooting. Inmates hoping to be released from prison will have a much tougher time getting out, even if they have new evidence for their case proving their innocence or they have a bad attorney. The Supreme Court has ruled that that's just too bad. If the inmate wants to go before federal court, they are not allowing it anymore. I asked my guests if politics had a role in this ruling.
Mike, are we seeing the results of politics now? Because this was a decision that was voted by the conservative judges 6-3. And Justice Sonia Sotomayor said, I can't believe we're going down this path.
Well, it's hard not to think that, you know, it's hard to think that politics are not involved. And honestly, it's hard to think. I mean, I think what we've seen, and honestly, I think since there was a big move for criminal justice reform after the George Floyd murder, I think what we're seeing at all levels, unfortunately, is a backlash to what was a genuine and strong push for criminal justice reform. I know we've seen it at the Texas legislature. I think we've seen it in our Texas governor. And I don't know, maybe we're seeing it at the United States Supreme Court as well.
Judge Fields, when we take a look at this, do you see any politics involved with a majority of the conservative 6-3 vote on this issue?
I see what we have always seen in the selection of Supreme Court justices, and that is liberal or more expansive ideology versus very restrictive ideology. And I want people to understand that when I say liberal ideology, I'm talking about the majority that we have now. This is the most outstructured liberal way to interpret the Sixth Amendment that I've ever seen in terms of stare decisis. This is an established precedent. Conservative judicial philosophy says you don't touch it. You leave it alone. These justices have now said, no, we are upending years, decades of judicial philosophy to institute a new way of looking at these cases. That is a very liberal ideology. People get locked into these ideas of conservative and liberal, thinking conservative means right and liberal means left. No. When you look at how this decision is structured, it's a completely radically new, different thing that we haven't seen in decades. And that is disturbing because we need predictability in the law. And now we don't have it.
And just to be clear to the viewer out there, you're saying this is liberal ideology, but it's served up now. It's being served up now by the 6 conservatives.
It is liberal judicial philosophy, meaning that you can overturn cases on a whim. And we've seen that in a couple of things here recently. We've heard it rumored in one case in particular, but in this case specifically, to say all of that precedent, all of that old case law that we've relied on for decades and years, we're no longer going to rely on that on the turn of a dime. I mean, that is unsettling for lawyers who follow constitutional rights issues.
And Mike, you were able, through the Innocence Project and your hard work, able to successfully get Liddell Grant out, but you use the Texas State Appellate Court, right?
That's absolutely correct. In fact, you know, I teach a law school class on actual innocence and post-conviction remedies. And one of the things I tell my students at the beginning of every semester that they can't believe, they don't understand, they can't wrap their arms around it. And that is that the United States Supreme Court has never recognized actual innocence as a legitimate means for relief in the judiciary. I mean, they've had the opportunity many times, and since 1993, they've repeatedly held the Constitution there is no constitutional right not to be convicted or even executed, even if you're actually totally innocent. That you know, you have all these other rights, but if you had a procedurally fair trial, it doesn't matter that you're actually innocent. So yes, in Liddell Grant's case, fortunately, we were able to get him relief through the Texas Court of Criminal Appeals that does recognize a constitutional right not to be incarcerated or even executed if you did not do it.
And that's a problem.
Go ahead.
That's a problem. That's a problem because what happens in Texas is not necessarily happening in California or Indiana or Oklahoma. We need one consistent judicial standard, and that's been upended now. And as a former jurist, that is the thing that concerns me.
All right, gentlemen, thank you for joining us here on The Factor Uncensored. We'll continue to watch this and glad to have you both on to talk about it. Thank you, folks.